Welcome to Implicit Bias in Juror Decision Making, Sexual Orientation, Attractiveness, and Gender. I'm Anthony Ross, Chair of BHBA's Inclusion Section. I'm delighted to introduce our speaker, Dr. Russ Espinoza. Russ K.E. Espinoza, Ph.D., is a professor of psychology at California State University, Fullerton, where he oversees the Department of Psychology Research Methods curriculum. His research focuses on prejudice in the U.S. legal system, including modern forms of prejudice and the effects of socioeconomic status. He also works as a trial consultant in Southern California. And now let's get started.
Thank you, Tony, for that. I'm going to open up the presentation here, so give me a second. Thank you for showing up, taking time out of your busy schedule, everyone. Like Tony mentioned, I'm a forensic psychologist and professor of psychology, and I focus my empirical research primarily with juror decisions and biases that can exist with that. I'm not an attorney, so I can not offer you law advice or anything like that. I'm here specifically to talk about the science behind my research. I did go to law school for a year, but from what I understand, that doesn't make you an attorney unless you're Kim Kardashian. So let's go ahead and begin here. Implicit bias in juror decision making, sexual orientation, attractiveness, and gender. And so, what I'm going to speak about is in general the sort of research that I've conducted and others with regards to how jurors decide cases based on or the impact of extra legal factors that can bias juror decisions. And I'll speak more extensively about this particular study where we examine defendant sexual orientation, attractiveness, and then gender as well. So if we go back with regards to the intersection of psychological examination of the legal system, it began over 100 years ago with this person, Hugo Munsterberg, who began to examine this sort of the psychological impact of juror decisions. And Munsterberg's first studies really examined how eyewitness identification can be off and sort of those cognitive processes that exist that can throw off eyewitness identification. He also examined things like false confessions. What would make a person falsely confess to a crime, and he examined those aspects, and specifically the cognitive biases that exist within humans. And a lot of his earlier studies did examine the influence of aspects of eyewitness identification and false confessions on juror decisions. So, since that early research, over 100 years ago, I think he began his research studies in 1907. The focus of extra legal factors affecting juror decisions have found, race has kind of been that uh, prominent extra legal factor that has been researched. And that research really kind of sort of began to become a more extensive examination after the civil rights movement, and so that research that examined race as an extra legal factor affecting juror decisions really took off in the 70s and 80s and has grown since then. And other factors have been woven into the empirical research, things like socioeconomic status, gender, age, attractiveness, all of these things can have an undue impact on trial outcomes. But it really, from the 1970s, we really started to re-examine juror decision making. And race and ethnicity kind of was that big standout factor, extra legal factor that was the first area that we began to examine bias in juror decision making. Okay. And here's just a example of two different cases where the outcome was similar. Both defendants were found guilty of raping an unconscious woman. And we had Brock Turner over there, Stanford swimmer, higher SES defendant, um, found guilty of raping an unconscious woman and was given 6 months in jail. And we had the Vanderbilt football player Corey Beatty, raping of an unconscious person and given 20 years. And though the sentencing was conducted by judges, a great deal of the jury decision-making research has examined judges' decision-making as well. And so the overarching decision-making research in the legal system has examined jury decision-making, judge decisions, parole boards, probation, has run the gamut of it. But my talk here today is going to focus specifically on juror decisions. Okay. So other aspects with regards to extra legal factors contributing to the potential juror bias are things such as socioeconomic status. Low SES defendants have been perceived as more dangerous, more culpable, appear guilty significantly more than higher SES defendants. And that's because cognitively, it seems to align with the sort of human preconceived notions of how socioeconomic status can be an overwhelming or overriding variable that can contribute to sort of the cognitive decision making of jurors. If we look at gender, male jurors tend to be more punitive than female jurors. That tends to run across the gamut of crime, different crimes and different types of suspects. Tends to be female jurors tend to be more sympathetic towards jurors overall. Male jurors tend to be more sympathetic to female defendants as well. We've examined attractiveness of defendants as well. And we know that more attractive faces of defendants tend to be treated more leniently in the decision-making process. I teach psychoprejudice and discrimination here at Cal State Fullerton and psychology and the legal system. I tell my students, it's really good to be rich and good looking if you're arrested. So I try to get my students to strive to being those things. We've seen that lower SES and attractiveness tend to be driving biasing variables, especially in the juror decision-making process. When we look at sexual orientation, not a great deal of research has been conducted with regards to sexual orientation of defendants. But in general, we can say that homosexual defendants have tended to be judged more harshly based on sexual orientation. And this is especially true when the crime committal was one of passion, such as murder of their partner. So the research starting again, there was a re-examination of the bias of these extra legal factors in juror decision making, and it really there was sort of less focus after Munsterberg in the early 1900s, but it really began to take off in the 1970s and has grown since then. But a great deal of that early research from 1970s to maybe 2000 didn't really come up with theoretical explanations for this bias. Remember that the civil rights movement tended to drive this re-examination of bias in legal decision making that really took off starting in the 1970s. And so the theoretical explanation for it, or the sort of cause behind this bias, was more an explanation of explicit bias. When we started to examine prejudice as social scientists, it was easy to go out and examine bias. We just asked people, do you hate this group? Yeah, I hate that group. Okay. And so there wasn't really that sort of socialized pressure to respond not explicitly. So with this examination of what is the theoretical component behind what is driving the potential for juror bias, we started to examine two different um, cognitive processes for this potential bias. And so we began to compare these explicit biases and implicit biases. And again, um, finding somebody who was racist or prejudiced against any particular group. Um, when we began this research, and not we, I was 3 at the time, but when social scientists began to examine this research, re-examine juror decision making in the 1970s, the questions were explicit in nature. Okay. And the questions towards participants in various empirical research studies were directed towards this explicit bias. Which, how does explicit bias happen? It's due to specific thought processes that we are aware of while we're thinking these things. This explicit bias is communicated directly, which is why when we were examining prejudice in the 1970s, we were examining explicit bias particularly. There were a couple of examinations of implicit bias, but that didn't really take off until the more towards the late 1990s. So it's communicated directly, which makes sense that the researchers examining bias um, ask pointed questions that could be answered directly and communicated directly and would convey a sort of explicit bias. It's conscious thinking by the perpetrator of explicit bias, and it tends to be perhaps not fairly well planned and organized, but the thought processes of those who express explicit prejudice, they have a preconceived notion or plan, and it's organized with regards to the targets of this prejudice, and the way we would express explicit prejudice. That is fairly well organized for somebody expressing explicit prejudice or explicit bias. Implicit bias, again, we started to examine, after the 1970s, which were reacting from the research was reacting from the civil rights movement. And so people were still openly expressing explicit bias. Society said it was still, okay to express that. Then late 70s, early 80s, and then through the 80s, that societal norm of it's okay to express this bias in an explicit manner really began to take shape, and that sort of social characteristic of what's acceptable and not acceptable began to take root over society, and prejudice, racism really began to be viewed as a non-normative expression. Okay. So then we had the 90s, which began to uh, the research examining implicit prejudice had to take that into consideration, and we had to start examining bias in a different way. And so implicit bias began to happen. And what is implicit bias? It happens without thinking. It's communicated indirectly because somebody might not be fully aware that they hold biases towards persons. Of this group or that group. It's subconscious actions and thoughts. So, where prejudice is more of an affective feeling, discrimination is a behavior. And so even the discriminatory actions tend to happen at a subconscious level. Okay. And these implicit cognitions tend to be more spontaneous and not planned. It tends to be reactionary depending on the particular situation. Um, So we began examining that implicit bias in the 1990s, but as I had stated previously, there were still examinations of explicit implicit bias, that began, just not a great deal of it, that began in the 70s and 80s. And these two researchers, Davidio and Gertner, coined this phrase aversive racism way back in 1986. Okay. Um, and their early research was specific to black and white relationships, and more specific to white persons who genuinely, explicitly harbor no prejudice towards black persons. Okay, um, and so aversive racism, it was not coined for KKK members or neo-Nazis. They're perfectly comfortable expressing explicit prejudice and racism. It was for those who believe, hey, I don't have any prejudice towards this particular group. And again, their early research was specifically white on black persons. Okay, so white beliefs towards blacks. And it was for those who believe that they really are very, very low in prejudice. And the research kind of showed that a person can be very, very low on prejudice overall and still express aversive racism. And so um, that aversive racism research, really began to take foot and take hold for social scientists because it was a good explanation for why, particularly white persons who might internally believe that they harbor no prejudice towards blacks. It was a reasonable theoretical explanation for, well, then why are blacks found guilty more than whites for committing the same crime? We just showed that picture of the two different defendants. Why are blacks tend to be sentenced longer? And again, this was back more in the 70s and 80s. It's the examinations become a little bit more complex. It's not just based on race. And so aversive racism, this theory, began to state that. And due to the fact that this implicit form of racism was based primarily on an aversiveness. So it's not that they hold explicit prejudice towards blacks. It's that there is a sort of a aversiveness, a sort of uncomfortableness. And that uncomfortableness, internal though it may be, though it may be, can rear its ugly head in aspects like the decision-making process that jurors face. Okay. Though the theory of aversive racism was coined way back, in the 80s and explains bias by whites towards blacks in this subtle form, it has grown to involve and include other marginalized groups. So that original research really examined implicit bias uh, by whites who may harbor no explicit prejudice towards blacks, but we took that theory and then started to apply it to different groups, different marginalized groups, Hispanics, Latinx community, even disabled, sexual orientation, which is what I'll be primarily focusing on with this presentation. Okay. So aversive racism has now morphed into aversive bias to cover non-racial marginalized groups. And aversive racism is implicit. It is not an explicit form of bias. So the theory of aversive bias in jury decisions, and when we look at that, the key component to aversive bias in juror decision making um, is that, and here's the sort of the beauty and I believe in the regarding the complex nature and understanding of aversive bias as it applies to something like the implicit bias of juror decisions, is that marginalized characteristics like race, disability, sexual orientation, ethnicity, all of these things, immigration status, um, the theory of aversive bias explains that those marginalized characteristics have to be coupled with another perceived negative variable, such as low SES, unattractiveness. Um, a lot of my research has focused on such things as immigrant defendants, immigrant victims, um, also aspects like mental illness. How does that contribute to juror bias? So the marginalized characteristic, such as race, is not enough to explain the bias by jurors. So in a nutshell, aversive bias or the theory of aversive racism or aversive bias would explain the fact that jurors would not find a defendant guilty simply because they were black. So the research shows that we look at a defendant here's a defendant who's white, here's a defendant who's black. They're accused of committing a particular crime. Okay. Well, um, the research shows that if the only variable that is different is race of defendant, that jurors would not find the black defendant guilty significantly more than the white defendant. There has to be something else involved there, coupled with that racial variable. So, for example, if we had that black defendant and that white defendant, and the charge, the crime, was something perceived as a low SES type of crime, a blue collar type of crime, which might be something like robbery or let's say carjacking. Okay. Then a jury member would look at the defendants and it would make sense cognitively. Oh, I can see why the black defendant stole the car. If we add another perceived negative variable, socioeconomic status, so let's say we have a uh, uh, upper middle class white person and a lower SES white defendant, and then we had an upper middle class black person and a lower SES black person. So we had four different defendants, and they all were accused of committing the crime of carjacking. Well, the jury would find the low SES white defendant and the low SES black defendant guilty significantly more often and find them more culpable because it would make sense to them cognitively. Oh, they're poor. I can see why they need to steal the car. It would make sense in their reasoning. However, what we found is even though the poor white defendant and the poor black defendant are found guilty more often and found more culpable than the higher SES defendants, we do find that jurors find the low SES black defendant even significantly more guilty and more culpable compared to the low SES white defendant. And that, in a nutshell, is sort of the theory of aversive racism and aversive bias, and how it is a reasonable explanation for potential bias in juror decision making. Okay. Um, my past research examined juror aversive bias based on things like defendant and defense attorney characteristics, juror race, immigrant defendants, and this particular study that I'm going to go over in greater detail with regards to sexual orientation of defendant. So for these prior studies, results confirmed that other perceived non-racial negative variable needed to be present for bias to occur. So I examined the racial characteristic of ethnicity, and so I varied things like defendant and defense attorney ethnicity and things like that. We looked at juror race and ethnicity, and then immigrant defendants. We examined things such as country of origin. So if we had a defendant from Canada, an immigrant defendant from Canada versus an immigrant defendant from Mexico, we would find aversive bias in the juror decisions. So results of these prior studies did demonstrate this sort of aversive bias that seems to be taking place with juror decisions. Now, well, we'll continue on. Let me go back here. The research on aversive bias and bias in general in juror decision making tend to focus on two different types of participants. We use in the social science research primarily undergraduate participants acting as mock jurors. Okay. And the decision making from undergraduate college students, comparing that to real jurors, can be vastly different. But I have a slide coming up which will explain how they can be quite similar as well. So we'll look into that in a couple of slides. So the current research with regards to what we call aversive heterosexism, okay? And so remember, the theory of aversive bias was primarily developed for those who harbor very little explicit prejudice towards groups. Okay, it's an implicit bias. There's a sort of aversiveness for it. So if we apply it to aversive heterosexism, the a heterosexual person would externally and cognitively think, I don't have prejudice towards gay people, but there is an internal implicit underlying mechanism there that can sort of promote discrimination towards non-heterosexuals. Okay. So heterosexism states that society's sexual orientation default is heteronormativity. And, that's based on statistical percentages. And we don't have an accurate understanding or percentage of what percent are heterosexuals and what percent are not. We hear percentage estimates of 5 to 15% of the general population are not heterosexual, but it's tough to really get an accurate statistic on that. So heterosexism also builds upon a hierarchy that heterosexism is superior to homosexuality and bisexuality. So if a person is heterosexual, and predominantly our society is heterosexual, there can be this underlying implicit existence of bias that is going on. So heterosexism is applied in everyday life. It impacts individuals' attitudes towards sexual minorities. Heterosexism does not just allow for discrimination towards sexual minorities, but promotes this discrimination. So Dr. Coons, who's here at CSUF, and myself wish to explore what might be an other perceived negative variable that would drive aversive heterosexism. So remember that in order for aversive bias to accurately explain the biasing decision making of a participant in a study, um, the marginalized variable needs to be coupled with another perceived negative variable. So, as previously stated, that past research has shown defendant attractiveness, a juror gender, can disproportionately influence juror decisions. So, the theory of heterosexism postulates that current societal views on acceptance of negative bias towards gay men and lesbians are diminishing. Okay. You can, the Supreme Court decision regarding uh, marriage between two men or two women, um, we can see that it might be primarily reflective of how society's views have changed over the past 50 years with regards to um, homosexuality. So people generally today hold egalitarian views, and I say people generally. Um, in empirical science, we never speak of black and white um, findings, and we don't speak in absolutes. And so people generally, we're talking about majority of society, hold egalitarian views towards gay men and lesbians. And this is especially true for younger and educated individuals, okay, who tend to be more liberal thinking. And that's especially true for college students who tend to be more liberal thinking. Aversive heterosexism in juror decision making, not a lot has been examined regarding this marginalized group. Applied to the legal system, aversive heterosexism theory holds that jurors will not demonstrate blatant bias towards minority defendants based on sexual orientation alone. And by minority defendants, we're talking about sexual minority defendants. Only when sexual orientation is coupled with another perceived negative variable, something like unattractiveness, will jurors show some form of bias. And the reasoning is implicit aversiveness they may feel will no longer be based solely on sexual orientation. So the central hypothesis to our research study is defendant sexual orientation, defendant gender, and defendant attractiveness will interact to promote juror bias, and primarily from male jurors, because this is what a great deal of past research simply examining the differences in juror decisions based on juror gender shows that males tend to be more punitive than females. So we hypothesized defendant's sexual orientation would not be sufficient to demonstrate bias. Only when coupled with level of attractiveness will male jurors primarily show bias. We hypothesized females may show some bias, but it wouldn't be to the extent male jurors. So, what are the materials we used? We created a trial transcript that described a murder of the defendant's partner. The trial transcript included a description of the crime, an overall case summary, prosecution and defense summaries, including witness testimony and closing arguments for prosecution and defense. And so here's just the cover of this trial transcript. And this particular um, uh, condition was for the attractive male. Okay. So we vary defendant sexual orientation, heterosexual or homosexual, defendant attractiveness, attractive or unattractive, and defendant gender, male or female. And this formed a 2x2x2 between groups design. Sorry to take you back to your undergraduate research methods class. We also examined jurors' differently. We examined males jurors separately from female jurors. We could have combined this to form a 2 by 2 by 2 by 2 design, but we didn't have enough um, uh, uh, participants in our study to provide adequate validity, or what's known as power, for our examination. So we had 494 undergraduate students acted as mock jurors. The participants' mean age was 20, fairly even split between males and females. So here I'm coming back to the talk of, or my point of, mock juror research versus using actual jurors or veneer persons. So though our mock juror demographics do not represent actual jurors in age and race, research has shown there is a high correlation between mock juror and veneer person research, but that the higher correlation is dependent upon obviously particulars. And this research by Bornstein in 1999 that showed this high correlation of research didn't really take into consideration the extra legal factors of demographics and how that can contribute to biasing juror decisions. It looked more at crime type and the outcomes of juror decisions. So in addition, research on juror bias based on demographic characteristics has shown college student mock jurors tend to show less bias compared with actual jurors, right? We see that, only 30% of the United States has a college degree. And the average age of jurors across the United States, 35 to 45, that's a very large age range, containing the largest percentage. And it's less than 30% are college educated. So when we look at the socio-demographic characteristics and the particulars of our study, it doesn't match up well. However, if we were to find bias with our mock jury participant pool, it would almost certainly be more pronounced with the actual veneer persons or the actual jury pool in the United States, given the fact that our participant pool is younger, more liberal, and less biased towards socio-demographic aspects. So we had four main dependent measures for this study. The categorical variable of verdict, the categorical variable of recommended sentence, the continuous variables of culpability ratings and defendant trait ratings. And we wished our materials to have a good ecological validity, meaning we wanted them to accurately resemble court documents and things such as that. So because evidence in the trial transcripts was weak, and we purposely designed it that way for this particular study, and the reason why we did that is because we have found with prior research that the categorical variables of guilt and recommended sentence tend not to show significant differences based on these socio-cultural factors. We tend to find more significant results based on the continuous variables of culpability, trait descriptions, rating the defendants and or victims and things like that. But again, we kept the categorical variable of verdict and recommended sentence in the materials to better resemble actual court documents. So here's an example of a culpability questions, and we had many. at least 17, something like that, 15, something. And so, in your opinion, how responsible is the defendant for committing this crime? And so here we're looking at Likert type scaling questions from not at all responsible to totally responsible for things such as responsibility, blame, and then confidence in their decision. The juror member confidence. How confident are you in your decision? And like I said, we had more culpability measures than this, but these are the ones that we found significance with. And so if we look at this in greater detail for our study, we can look at this bar graph and look at responsibility. And so this is for male jurors. So we're examining male jurors with these next few slides. When we look at these bars, what do they represent? And so we have the gay male defendant who's unattractive, the gay female defendant who's unattractive, the gay male defendant who's attractive, the gay female defendant who's attractive, the heterosexual male who's unattractive, heterosexual female, heterosexual male, heterosexual female. So those were our independent variables for this particular study. And as we look at this table, we can see that male jurors found the unattractive gay male significantly more responsible, okay, than all other conditions. The gay female who was unattractive, they rated this defendant more responsible as well compared to the other conditions, but not as much. It's significantly more when the defendant was a gay male. When we look at the culpability measure of blame, they also blame these defendants significantly more than all other conditions there. And a unique finding was that they were more confident in their decision. And this is a good table to examine when we think about the overarching theory of aversive bias as it applies to aversive heterosexual or aversive heterosexism, because aversive bias explains the implicit bias that is within someone. Okay, and implicit bias, as we've previously went over, we're quite unaware of those implicit biases that exist and it exists within all of us. Every human walking the planet is prejudice at some level. Okay, but aversive bias explains that as we are simply unaware of it. What's interesting about this finding regarding confidence in the decision is that they were cognitively aware of their confidence, okay, which kind of demonstrates that their implicit bias towards or in favor of heterosexism is that confidence is more explicit in nature, okay? And it sort of just solidifies the bias that can exist within us. When we looked at the personality trait ratings, we had things like trustworthiness, aggressiveness, attractiveness. And so for this example, we looked at trustworthiness. And here's an example of the question there on a 9-point Likert type scale. And we can see that the trustworthiness that male jurors had towards the gay male defendant who was unattractive, they found them just, they rated those personality traits significantly lower. And again, we didn't find main effects for male jurors for bias towards a homosexual defendant accused of murdering their partner. It was only when sexual orientation was coupled with these other perceived negative variables, such as unattractiveness. Um, did we find some significance? So, though we hypothesized primarily significant findings for male jurors, female jurors did demonstrate some bias. And just for lack of time and describing the results of this study, I've touched on some of the primary findings that we had. There was more significance involved with male jurors. I just for time I can't get into greater detail, but we didn't find those main effects, those decisions based solely on sexual orientation. We didn't find a bias towards that. And here we can see that for female jurors, we found some significance regarding their confidence in their decision. So when that heterosexual male was unattractive, female jurors were much more confident in their decision. Um, and I believe, and Dr. Coons as well, with our explanation with our results for this study, we believe that this might be primarily uh, due to the socio-demographics of our participant pool. Remember, college students, average age 20 years old, and young college students tend to be significantly more liberal than other demographic groups, right? And so this might explain their confidence when the defendant was heterosexual. So, as hypothesized, we did find a significant three-way interaction for male jurors, demonstrating aversive heterosexism. And so, again, my apologies to taking you back to your undergraduate research methods courses. Um, when we examine two or more independent variables at a time, we do this, and they're called factorial designs. We do this because we believe that these two independent variables interact with each other, meaning that um, the we might find significance with this independent variable. We might find significance with this independent variable, but when we couple them together, we will find more significance. And that's that again. It's called a factorial design, and that's a most of psychology kind of uses factorial designs in our research method structure, and the reason is because there tend to be multiple cause explanations for human behavior. Okay, it's generally not just one thing that's contributing to this behavior, but it's probably not 1,000 things either. So we examined three independent variables for this study. We examined the sexual orientation of a defendant, we examined the gender of the defendant, and we examined the attractiveness of the defendant, hypothesizing that these three things would interact with each other to demonstrate juror bias. If we examined, and we did examine just the independence alone, so we examined, statistically examined just sexual orientation of the defendant. We statistically examined just the gender of the defendant, statistically examined just the attractiveness of the defendant. And we didn't find very much, especially with sexual orientation. We did find some things with attractiveness, but that wasn't built into our hypothesis. The heterosexual, the aversive heterosexism was built into it. And we didn't find what was called a main effect for that particular variable. Homosexual male defendants rated as unattractive were found more responsible, more blameworthy, and jurors had more confidence compared with all other conditions. And the reasonable explanation for this bias is aversive bias And aversive bias explains that implicit bias that exists in all of us, for persons who genuinely believe that they harbor no prejudice towards a particular marginalized group. These defendants were also found less trustworthy. And so when we think about how would these results transfer into you as attorneys, I hope that speaking and sharing the results of this research um, isn't just it just doesn't stop there. Well, what can be done about it, right? What, if this aversive bias exists in juror decisions, you know, where do we take it? How can these results impact, have a genuine impact? Well, we disseminate results to legal bodies like I'm doing here. I've done past research on wording of instructions to juror members. I did a study where we examined the CalCrim and CalJIT wordings regarding California law, and found significant differences by just changing wording. When judges give instructions to jurors, okay, and so if these sociocultural factors are present or salient in a particular case, judges' instructions become uh, uh, important. And what we found with our examinations with judges' instructions is we can find significant differences in jury decision making based uh, on whether or not the judge's instructions are prohibitive or informative. And so if the judge instructs a jury, listen, the sexual orientation is predominant in this case, or alluding to that in some way, if the judge's instructions are prohibitive regarding the jurors' decisions, jurors tend to uh, react opposite of the judge's instructions. Okay. They feel that their sovereignty has been taken away, and so they're going to react opposite. But when the judge's instructions are informative, here is what might be at play when you go to come to your decision. We tend to see that the bias can be lowered. And so I didn't want Dr. Coons and I didn't want this research just to end and die right then and there. To a lesser extent, male jurors also demonstrated bias towards the unattractive female homosexual defendant on these culpability measures. Female jurors didn't demonstrate a great deal of bias for this particular study. We have found that female jurors can be biased as well. Tends not to be so much for sexual orientation. And again, we have to take these results. We found, let's say, this amount of significance with this study, but because our participants were acting as mock jurors and they were much younger and more liberal minded, more than likely. Well, actually, not more than likely. They were more liberal minded. We did examine that. Then the jury pool across the United States, we would say that the significance that we found would just be exacerbated in a with veneer persons, with a real jury. So, though past research has shown significant correlations between mock juror research and veneer persons, for our subject matter, not much has been known. There was that Paramount research study in 1999 by Brian Bornstein that showed there was a good deal of connective correlational tissue between mock juror research and veneer person research. But we did find a good deal of significance with our younger more liberal mock jurors. So future research should consider using actual jurors. The problem with that is funding, right? We need funding to pay veneer persons, and working with the court systems, as I'm sure you know, can be tedious and arduous and all of that. So, well, listen, thank you for listening. And again, I want to reiterate, I'm not an attorney. I can convey no great knowledge with regards to the laws. Um, but I hope I've conveyed how implicit bias can weave its way into juror decision making. So there we go.
All righty, Dr. Espinoza. It looks like we have quite a few questions.
Oh, okay.
First one is from Carlin Dawn asking, do juror biases affect how they view counsel? In essence, more likely to be persuaded by a male attorney versus a female, or an attractive attorney versus an unattractive?
Yeah, a great deal of research has been done on counsel characteristics, and it's similar in finding, meaning that it's also sort of dependent upon crime committal and what is the defendant is being accused of. So, for example, if we look at gender differences of counsel, if a male is accused of rape of a female, having a female counsel tends to benefit the defendant with mock juror research. Attractiveness of counsel hasn't shown a great deal of significance. Same race, same ethnicity can bias the juror decision. I had posted a study we did where we looked at defense attorney characteristics. And when the defense attorney was the same race, ethnicity as the defendant, that biased juror decision making for white jurors. So it can have an undue impact, certainly. Yeah.
Alrighty, thank you. And it looks like we have another question. Let's see. Do you have a comment on the risk of aversive bias directed towards attorneys for the parties in litigation rather than criminal defendants by judge and jury?
No, I don't. The bulk of my research does focus on criminal defendants, and
Okay,
in the
perfect.
criminal court. So I'm not an expert in that. There has been research done with different court systems, juvenile court systems. I have done some of that, but the primary focus of my expertise is in the criminal court system.
All right. And then let's see. It says, Danny Sawaf is asking, how may a lawyer change a juror's bias in limited time? Is that even possible?
Yeah, that's an excellent question. And again, as I was kind of stating at the end, as an empirical scientist and somebody who does research in this, it's sort of my job just to present and disseminate these results. But so as an attorney, um, you know, how can you either again, I don't want to get into the legality of your profession because I'm not an attorney, but as you probably know, extra legal factors play a role, and they come out during trial. And so, as an attorney, by understanding these biases that may exist, um, uh, working your arguments in the courtroom to favor your side is probably the best connection to my empirical findings that I could give you. I've been a trial consultant. I've worked in that area in voir dire and sort of the story of the case and things like that, presenting to a jury. But I'm not a hired gun trial consultant, and so a hired gun expert witness or something like that might favor your side, to either lower this implicit bias that might exist, or, and I hate to say, maybe raise it if you were on the opposing side. I hope that answered your question, but not sure it did.
Great. Let's see. Okay, so it looks like Heather Atkinson is asking a question regarding your study. Okay. A little bit confused, not understanding your point. Are you saying that jurors do not consider heterosexuals defendants as responsible or trustworthy? We could.
Well, for this particular study, okay, remember we combined those extra legal factors, okay? And so we were specifically examining aversive heterosexual or heterosexism. Okay. And so jurors, there is a great deal of research examining these gender differences. But with regards to male jurors and female jurors, male defendants, male victims, female victims. But there's not a great deal of empirical research examining sexual orientation of defendant. Okay, there's our study and maybe 2 or 3 others. So I'm not saying that there's not bias towards heterosexual defendants, not at all. It's what we specifically examined demonstrated that there appears to be, especially for male jurors, more bias towards sexual minorities, and that would correspond with just the social demographic research, sociological research that's been conducted on how males and females feel about sexual orientation. Females tend to be more comfortable with minority sexual orientation than males, and there could be possible explanations for why that is. I hope I addressed your question there adequately.
Alrighty, so it looks like we just have one question. Has your research ever touched on the race of the judge or its impact on the jury?
Yeah. There has been. I did one study a while back that examined judge race. But in what we find with actual research based on the statistics of the courtroom, okay, we do see some same race favoritism in juror decisions based on the race of the judge. So, for example, let's say the defendant is black and the judge is black. Okay, we tend to see a bit of juror decision favoring the black defendant over if the judge was a white judge. There would be less favoritism towards the black defendant. We see that with white judge and white defendant as well, to a lesser extent, other ethnic groups, Asian, Hispanic. Yeah.
Alrighty, well, this looks like we're out of questions. This concludes today's presentation. Thank you so much, Dr. Russ Espinoza, for an excellent presentation today. And thank you so much to our audience for joining us today. Have a lovely day, everybody.
Thanks for showing.